Hello and welcome to Coproduce Care. Today we have with us the wonderful Belinda Schwehr, who is the Chief Executive of CASCAIDr. So welcome, Belinda. Thank you for joining us. I wondered if you could introduce yourself and what you're doing at the moment and your background.
Okay, well, I'm a lawyer by background and a sort of maverick, mouthy commentator by inclination. I've started a charity to give people legal advice about the CARE Act because 20 years worth of teaching local authorities how to do it as lawfully as possible came to a juddering end once the CARE Act had come in. And my concern was that if nobody is having legal framework training in local authorities about new legislation, it was very likely that the way the CARE Act was implemented would probably contravene well-established public law principles that are the bedrock of disabled people's rights. 2 years into the charity now, I still go back to local authorities and do training, but my main focus is keeping the charity growing and solvent and making waves, really.
Brilliant. Thank you for the introduction. I want to go back to CASCAIDr, which is the charity, and it actually stands for Centre for Adult Social Care, Advice, Information and Dispute Resolution.
It does, yes. Well done.
Well, I've come prepared. So that is the charity that you're working for, you were just talking about, and it would be interesting to find out a bit more about the work that you're doing there. And then we can talk a little bit about the CARE Act and just introduce people who might not know what it is to the CARE Act. So could you just maybe give us some examples of the advice and information that you provide in CASCAIDr? And as I understand, it supports people all over the country, so it's not regional.
Yes, the special thing about it is that it is nationwide and it is not client group specific. So we cover the whole of the client population, anybody 16 years and older who is affected by adult social services or healthcare law. So we cover people who are having trouble with their continuing healthcare, as well as people who are having trouble with their assessment or their care plan or their direct payment or their revision of their care plan, their cut, in other words. We give legal advice about whether the council is challengeable in respect of what it's done, and if not, what is the best thing to do to change the situation for the future. It's really difficult for people to understand that there's no appeal in adult social services law. So if you don't like your care plan, you've got very limited options. And knowing some law and knowing what to say, some people would say it was a way of he who shouts loudest gets the most. But to my mind, it's a way of saying if people are legally literate about their own legal rights, they won't feel so vulnerable and they won't be so likely to be fobbed off with an insufficient care package. So we do everything from the beginning, the assessment and eligibility stage, right the way through arguing about indicative resource allocations and finalised budgets. And then we look at the deployment route, whether that's going to be a direct payment or a commissioned arrangement in a care home or for domiciliary care. And then we go all the way onto the annual review and what to say when the council comes by next year saying that they've been told to go forth and subtract, as it were, because they don't have enough money themselves back at HQ. That's really what the charity is all about.
And in terms of, I was going to ask you, why does the law matter so much in cases like this? Because you'd think when you're going for care, you just want to have care provision and you just deal with a council, local authority provider, and you get the care that you need. Why do you feel that people are coming to you for advice and that you're having to seek recourse through using legal instruments?
Well, ever since 1990, when local authorities were made responsible for contracting for people's care if they didn't want to provide it directly themselves, they have been funded by central government, probably inadequately, regardless of the politics of the government of the day. And therefore, social workers have had to ration the money that is available to spread it thinly between an ever increasing client population of needy people. And as the demographic starts to explode, that increase of people with learning disabilities who are living longer, and the increase in people of aged over 80 who may be cognitively declining but growing in numbers, you can see that the maths are not going to get any easier. So poor social workers who are professionals have to tread that line between being employed by a council that never has enough money and being therapeutically supportive to members of the public who have legal rights against the council. And from that perspective, law matters, because this is public law. And as I said, there's no appeal, there's no tribunal, there is only judicial review, which is a fairly ethereal and high-flown body of principles which are not part of people's ordinary general knowledge.
Right. So it's actually a very complicated landscape in terms of challenging decisions, which is why people have to come to somebody like yourself. I wanted to move on to the CARE Act. And could you explain what the CARE Act is and what protections or support it's supposed to provide for people?
Yes. The CARE Act is a piece of legislation that came in 2015, which was supposed to modernise and make much more explicable and accessible the law governing who gets what and in what circumstances from a local authority. It's nothing to do with benefits law, it's the law of access to services if you either haven't got the mental capacity to make arrangements for yourself, or if you haven't got the money to pay the market price. So if you like, it's an aspect of the welfare system. There's a social care safety net out there, but in order to be protected and inside that safety net, you have to jump through a lot of hoops and hurdles, all about being found to be eligible, and then your needs will be filtered down to needs that your family would be prepared to meet, but the council must pay for the shortfall. And the services range over all kinds of activities of daily living that make up people's quality of life. For instance, personal care, access to nutrition and hydration, being properly dressed, keeping your house habitable, getting out and about and using local services, and having help even with parenting if your disabilities or your illness, if it affect the capacity that you have for parenting and you happen to be responsible for a child. So the protections for members of the public really are to do with the principles that have been forced into the CARE Act. For instance, there's an absolutely general fundamental principle that councils must promote people's well-being in and about all they do under the CARE Act. And that's kind of the guiding principle, such as is best interests in mental incapacity law. You would say that promotion of well-being is the guiding principle in the CARE Act. And there's lots of rules about accountability and transparency. People are entitled to bits of paper about stuff, they're entitled to reasons, they're entitled to be assured that the council must seek their agreement, or at least take all reasonable steps to achieve it before the council gives up. So there's a lot to do with person-centeredness and co-production in the CARE Act. And that was the modernising part of it. The law before then just basically said, you will have what we think it's appropriate to buy in bulk. And people were squished into services instead of their care plans being needs-led and focused on the outcomes that they would like to achieve, as well as what the council has got to achieve.
So it's one of those sort of consolidating acts where you have lots of different legislation beforehand over 6 years, lots of kind of like out of date legislation, and it's just bringing all of that together, and you've got quite clear principle of well-being, and then you talked about accountability, and being more person-centered, and the focus on co-production in the Act, and also there's the statutory guidance, I think, that goes with it.
Yes, that's the theory
That's
of it.
theory. Is that, from your experiences, are we meeting the CARE Act? Are we doing what it was supposed to do?
Absolutely not. No. And I can say that absolutely trenchantly because of the problems that people write to CASCAIDr about. I get cases where there is no care plan and there has been no assessment since before 2015. So the person's paperwork is 5 years out of date and still referring to an approach to budget allocation that was governed by fair access to care services and fairer charging. And both of those policies are well out of date by now. I get cases in from people who have been told that there's no possibility, for instance, of using a direct payment to employ one of their relatives. And this is just legally a lie. And therefore, I feel very strongly that something has gone badly wrong in the commitment to implementing the promise that the CARE Act contained.
Why do you think there has been such a lack of implementation? I remember when the Mental Capacity Act came out, and there was a lot of press, there were leaflets, there was information, there was training. I feel like there's not really been anything like that at all for the CARE Act.
I'd have to disagree with you there because I was involved in going to over 40 authorities with a team of 20 people on public money. I think one of the problems was that the regulations and the guidance were only finalised very shortly before the CARE Act came into force. And the government was extremely slow in divvying up or even being transparent about the extent to which it would fund training. When that money was divided up, different regions, different consortia of local authorities took very different views about the real need to do training. And I mean by that I was aware that some councils thought that you could do it in 2-hour sessions, and other councils thought you could do it by webinar. Other councils thought you could do it by e-learning. And other councils just used the basic material that was produced by Skills for Care with government money. And I'm not surprised that it was a difficult project to get the right level of expertise to the right people. But what's happened since, of course, is that austerity has bitten further and further, and management churn has happened. Half the workforce has been made redundant, so everybody is too busy to do the CARE Act properly because they've got such massive workloads. And I have to say, I've seen evidence of very cynical management consultants being brought in to make savings, who have just basically appreciated that the less well-informed the front line is, the more malleable they are, and the less empowered they are to stand up to management with serious references to the latest wheeze for saving money not being lawful, for instance. And so I think culturally, there has been just a panic about what local authorities can do to stay on the right side of government in terms of politics, but at the same time meet their statutory duties. We've seen some councils just go belly up in terms of running out of money, even reserves. And there are some adult services organisations in special measures at the moment at the council level, just because they don't seem to be able to operate efficiently. I feel very sorry for them because clearly, with 14 billion having been taken out of social care over the last 10 years, something had to go. I'm just sorry that it was a commitment to the continuing professional development of social workers, because I think we get the social workers we deserve. And if we dumb down social work, we end up with people getting arbitrary care packages that are incredibly different from their neighbours, and nobody knows what to do about it.
So you've been a trainer for social workers, and you've talked to me before about the issues that you think are worrying with the quality of training that social workers get. Can you talk a little bit about the issues that have come up? What are the type of training needs that aren't being met for social workers to properly implement the law?
Well, if I could give you this example, there is a trend in adult social services departments to look for tools or approaches to paperwork and recording that will save frontline time. For instance, there's a project called, or a tool called 3 Conversations at the moment. Many councils are using 3 Conversations instead of following the Care Act by the letter. Now, I've got no problem with a kind of presumption that people, human beings, would prefer a process to be easier rather than harder and quicker rather than longer. So I'm not suggesting that the 3 Conversations is dodgy in and of itself, but I am suggesting that unless it has been fitted in to the linear approach that the Care Act takes to looking for evidence, making a decision, checking that you've got it right, and then moving on to the next stage. If that 3 Conversations approach, which is much more informal, is kind of wobbling all over the place, and the Care Act is not being stuck to in terms of being able to show that you've done at least the minimum as to what it requires, then the risk is that people's assessments and their care plans will be invalid. So I'm thinking that the management cadres that have taken on 3 Conversations, they may have been legally literate or they may have checked it out with their legal departments, but fundamentally, I wouldn't be getting as many cases in to CASCAIDr if people were satisfied that a 3 Conversations model was Care Act compliant. So I think a lot of the money has been spent on training councils how to do 3 Conversations because it's going to save them time, and particularly on how to be person-centred and how to be asset and strengths based. But at the same time, we are seeing complaints going through to the Ombudsman and the courts, which actually turn upon the lack of Care Act due process, and social work staff positively mangling what you can do with a notion of encouraging the client to be assets and strengths based. So I think that the training money has been spent on the wrong things, and that the trainers maybe haven't understood that the Care Act isn't an option, it is a duty.
Yeah. You talked a bit about the ombudsman, the local government.
The local government ombudsman, but the local government ombudsman is now called the LGSCO, and that stands for Local Government and Social Care Ombudsman, because the ombudsman has a policing role over private providers of care who are just contracting privately with ordinary members of the public, as well as those who are effectively publicly funded through local authority care plans.
Great. So how can people complain to the LGSCO? Can they go straight there, or do they have to go through certain procedures and internal processes of complaint first?
Yes, the LGO's jurisdiction turns on the LGO being satisfied that the individual who's seeking to complain to the Ombudsman has aired the matter sufficiently with the local authority itself for them to take up a decision as to what their stance is. So most local authorities would expect people to complain first using the social services complaint system from 2009. There are other ways of airing a matter with a local authority, though, that don't involve getting stuck in the complaint system, which can be really turgid and long-winded. Sometimes the ombudsman will let you go straight to them, but only if you've, been very, very clear with a senior manager, for instance, as to what your grouse is, and they've just told you to bog off.
Yeah. So have you got any examples of ombudsman cases? Because they're quite transparent. They do publicise their cases, and I'm signed up to the newsletter and I do see them come through. So if people want to find out what's being contested, what's being, upheld, complaints that are upheld and they're not being upheld, they can follow that. But do you see a trend in any types of complaints that regard the Care Act and its implementation?
Yes, I see a really positive trend, I have to say. About a year ago, there was an article in Community Care from someone who said, if everything is so terrible in social care, why are there so few complaints? And that nearly made me choke because I was already on my knees in CASCAIDr. So I looked up his article, this chap's article, and it was an analysis of ombudsman's reports. And it said, well, there's only been a few about assessment, and there's only been a few about care plans, and there's only been a few about direct payments. And so I wrote an article basically deconstructing his article. And then I started noticing that the ombudsman's backlog was massive. And I can only assume that they've taken on more investigators because the constant flow nowadays of social care reports where fault and maladministration is upheld is absolutely mind-boggling. And of course, because it's CASCAIDr's duty to educate the public, we analyse the local government ombudsman's reports and we then write a legal commentary on them, because the ombudsman deliberately does not write in legalistic language. The ombudsman writes in layperson's language to make as big an impact as possible on council officers and on members of the public. But what we think we can see is that there's been a definite upswing in the number of complaints about assessment and eligibility and care planning and budgeting decisions. But more importantly than that, the ombudsman is getting less and less coy about correlating findings of fault with the underlying legal framework. So, for instance, in the old days, the ombudsman would say, this is poor practice and is non-compliant with the Care Act. Now the ombudsman will just say, this is in clear breach of the Care Act and it is unlawful.
Right.
Now, if you're not in the know, you could start to think that the ombudsman had sort of set themselves up to be a court. But what they're meaning is that as the law becomes clearer and clearer, it is more maladministrative and more culpable to actually be unaware of the law. And that's what the important trend is. The ombudsman's reports show that there is a massive, widespread unawareness of the legal framework, with councils and their complaints officers and their senior managers just like either crossing their fingers or literally it not occurring to them that it must be dodgy to do this, that, or the other. And that means that the heart of social work, its professionalism and its commitment to the rule of law, has just evaporated as far as I can see. And that is the concerning trend. So there's good news from the ombudsman, but what it reflects is really bad news underneath.
Could I be devil's advocate and say, if I was working in a local authority, this isn't about us, it's about government supplying us with the right money so we can train people properly and so we can apply the Care Act. Actually, this is out of our remit. Yes, complaints are going up. Yes, that more things are being done which breach the Care Act, but it's out of our control. Is that an acceptable argument to make?
No, I don't think it is, I'm afraid. And I've seen it on television, and I've seen the BBC basically giving people an opportunity to say that. I feel very strongly that local authority staff don't speak truth to power. So as they go up the management ladder, they don't speak the legal truth to the members in whose name they operate the budget and try to stay within the monies that the local authority has allocated to adult social care. Of course, it is right that the government is culpable as well for 10 years of austerity without sorting out adult social care. I think Mr. Johnson promised that within 100 days there would be the basis for a cross-party discussion about why the Green Paper hasn't actually emerged during Brexit over the last 2.5 years since it's been promised. But that's a political argument, and it is down to Treasury choice as to whether to fund the Care Act. I think everybody agrees that social care has been one of the hardest public services hit, and there isn't enough money for local authorities. But what local authorities need to understand is that running out of money in social services does not negate the rule of law and the need to discharge statutory duties. Statutory duties in the Care Act are enforceable. They are mandatory. And that's why, for instance, Farnham in Bloom would have to go by the wayside if Surrey County Council was running out of money for adult social care. People find this really difficult to understand, but that's what reserves are for in the coffers of the council, for managing statutory duties when there is no other money to do anything else. And people, I think, have always thought that children's services were statutory and that kind of adults wasn't. And that's just legally illiterate in itself. Judicial reviews used to come pouring out of the administrative court before the Care Act at the rate of about 60 a year. And those 60 cases contained principles by which councils had to abide, even if they had run out of money in adult social services. And judges have regularly said, a discretion is a discretion, but a statutory duty is a duty. You can't downgrade a duty into a discretion without breaking the law. And if you break the law, then what was the point of Parliament legislating for the Care Act if it doesn't even really operate as a benchmark for anything any longer? So I think that local government deserves lots of sympathy and more money, but I think that its leadership has been weak in making the politicians in local government see the urgency of speaking to their colleagues in Parliament, in whatever party they happen to be in, so as to ensure that this legislation was properly funded from the beginning.
I often wonder, when talking about how the law is just not being applied, what is the point of having it if it's not going to be supporting or protecting the people to the full effect of its potential?
Yeah.
What can be done outside of the people who are working within the system? Obviously, there's a culture problem. How can people challenge, whether it's people passionate about the area? I know you're very active, you blog, you're writing articles, you're on here, which is fantastic. Is there anything that we should or could be doing to challenge the decisions? Is it just a matter of awareness?
Well, one of the things that local authorities do pay a certain amount of attention to is service user forums in local authorities and carer forums. They get their feedback as to how their policies are going down amongst the client population from those forums. Now, I think that if those forums were funded to actually get educated, then there would be a counterbalance to the prevailing culture of just sticking everything on the internet and hoping that people are savvy enough to find out this advice and information for themselves. I think that having service users at training sessions for local authorities would be good. Although, of course, it would frighten the wits out of some social workers. I think that there needs to be a kind of rebooting of the culture, that it is misfeasance in public office to knowingly not abide by national legislation, and that it's not what you get promoted for, it's what you get sacked for. I mean, that makes me sound quite savage. It's just that I've been doing this for 20 years and it is impossible to turn that juggernaut around if it doesn't suit the entrenched management view as to what they're actually there for. So I don't think it's easy to challenge. I do find the ranting on social media about it, but then the failure of people who are ranting to be interested in legal remedies when you even try to tell them that the law would help them, I find that quite aggravating. You know, it's fashionable to say that the law is broken and that the law does disabled people no good. I've never heard such rubbish in all my life, but it's only any good if you can be bothered to get your head around it. So we feel in CASCAIDr that we take a lot of people to this knowledge, but getting them to even sip at it is very hard. And I'm not saying that that's because people don't care or aren't clever enough. I'm saying that part of that is that vulnerable dependent people do not want to challenge. And therefore they want other people to challenge for them. And then that becomes the problem, that the advice sector itself takes a kind of doing good unto others type perspective. So I haven't really got a grassroots answer for that. I've tried all sorts of ways of spreading the word in terms of very cheap webinars and everything just to keep the charity afloat. And we're doing fine. And we've got some really good news in our annual review. But it is still fundamentally the problem that if you need adult social care, you probably haven't got any spare money to get yourself better informed about it, and certainly not get legal advice.
And I suppose the argument is really you shouldn't have to be reactive to issues that come up like this so frequently.
Yeah. So if social workers are professionals, they shouldn't be embarrassed to tell a member of the public that their legal rights are one thing, but that the council is hard up. And can they grope between them towards a compromise? They shouldn't be embarrassed to say that, but they are. And so with judicial review, there's a right way of saying something that's a difficult conversation, and there's a wrong way of saying something that will get you judicially reviewed. I'm just thinking that it's better if members of the social work profession actually can have a difficult conversation, and it keeps them sane, and then they stay in the profession and we don't get so much churn.
I usually on these interviews I ask some cactus questions, which are prickly questions about health and social care, but for some of them I have been switching it around because I will be speaking to some politicians at some point, and obviously we are the other side of the election. If you were able to ask the government to do one or maybe two things to help this area of social care, what would you be asking?
I would ask them to do another impact assessment for implementation of the Care Act, and to ring-fence training money, and to ensure that Social Work England required evidence of an annual refresher on Care Act law.
So who is Social Work England?
They are the new regulators of social workers in this country. It used to be HCPC, but it's just recently changed to Social Work England. So all of those professionals who need to be accountable to a regulatory body have had to re-register and gather up their evidence of remaining, aware of important developments, and satisfy Social Work England that they are fit and proper to practice. So I would think that making it an aspect of one's social work qualification, that one had had annual training in the Care Act, and I do not mean in being assets and strengths based, I mean in how the legal framework is developing, would be one step forward for that.
I'm actually hoping to get someone from Social Work England on a call. It might be good to discuss with them their thoughts on the Care Act and training and
Yes.
implementation as well. So that's a good one to keep a mind of. I mean, do you think that the Department of Health and Social Care could be helpful in any way in this area?
I think they could be helpful, but I think that they are very understaffed in terms of actual policy leads on social services as opposed to health. And I think that they look to the great and good in the sector to actually take forward government policy. So organisations like TLAP and the Social Care Institute of Excellence, and organisations such as Skills for Care, all of these organisations are arm's length from the Department of Health, although some are funded by the Department of Health. And I think that it's the people in those organisations that are really responsible for the culture and the leadership's attachment to growing new professionals who actually know what to do with legal remedies, or what to do with the knowledge as to what you can do and what you can't do in a safeguarding context, for instance. My perspective has always been that if the leadership at least is legally literate, it will save shed loads of money, because it will enable people to hack through hours of waffling at professional meetings. If nobody knows what the legal framework allows you to do or requires you to do, it just absolutely multiplies the kind of multidisciplinary team, let's hide behind a committee decision sort of approach. So I just think that the great and good, rather than the Department of Health, are the ones who will be really taking this forwards.
Is there a little bit of a elephant in the room in terms of regulation? I know that as a care provider, if I'm not meeting certain legal duties, then someone might complain to the Care Quality Commission, the CQC. And I know when they come and do inspections now, they look, for example, at Mental Capacity Act compliance, sometimes. Should they have a bigger role in regulating the practice of commissioners? They don't at the moment. Would that help?
CQC does have a role in regulating the practice of commissioners. It's a very, very small part of their responsibilities. But for instance, for the last 2 years, a CQC team has been going round actually evaluating local authorities as well as providers. About 3 or 4 years ago, Norfolk County Council was complained about to CQC, and an organisation called Equal Lives asked CQC to use the powers that it has got, with the approval of the Secretary of State, to do an investigation. And once this had started, the Secretary of State realised that it would be better to do this in a different way. So what happened was that the Social Care Institute for Excellence audited Norfolk for its compliance with the Care Act, and certainly found it wanting in many and varied ways. So since then, I think that it has been understood in the DHSC that you do need somebody looking at council's behaviour and commissioning performance. So it's a bit like what used to be the social work inspectorate. And then there was a team that went round, but now that job has been given to CQC. So, I mean, not many people are aware of it, but it is in fact happening.
So it's happening, but it's
I think
not. Okay.
The real problem is that social workers are not required to do adult social care law. You don't have to be a social worker to do an assessment or a care plan. And in some councils, there's a really big imbalance between professional staff and people who have just been given a job of doing the Care Act. And they simply have to be competent. Now, competence is not defined. And competence is not defined even in relation to legislation that they must understand or be regularly refreshed in. The real problem is the more training that you require people to have, the less time they're spending doing their actual day job. And the whole problem is that there's too few people employed to operate the Care Act, because local authorities have had to save money and make half the workforce voluntarily redundant. So it's a chicken and egg thing. It's a really, I think, complex problem. If you pull on one little string in one place, then everything else starts to crumble in another place. So I don't think that there's an easy fix for whose responsibility it is to ramp up social work knowledge. I just think that people are not competent, and sooner or later there'll be a case where the judge will say, what were this person's qualifications for coming up with this prose that doesn't pay any attention to the Care Act's linear process and requirements for making particular decisions. And it'll turn out that it was the tea lady or the postboy.
It would be helpful if something like that came up and that it got a lot of attention. But then that's it. You're waiting on things to go terribly wrong, and you're waiting for a potential opportunity for a judge to make that judgment, and then for it to get a lot of press or attention. You're waiting on things, and it's very kind of reactive and slow.
Yes, what I was going to say was that councils are infamous for avoiding judicial precedents. They might fight and fight and fight and fight, and then the person gets legal aid, and they will continue to fight and fight and fight until the person gets to court, and then outside the door of the court they will make an offer that is generous enough to cease to justify the person being legally aided, and then the case will be settled by way of consent, and the precedent will not get to court. That's called managing a litigation risk. I do not think that it is a public sector ethical approach, but it has become accepted as being the basis on which all senior management operates. What are the chances of getting caught? Or if we do something this way, if anybody challenges us, then can we say, well, we'll do it a different way now for you, but carry on doing it the other way for everybody else? That is the culture.
It's awful to think that that is the culture, and obviously it's the culture that's being accepted and promoted by leadership within some of these local authorities, which makes it even more heart-wrenching, really. And what are the systems that we have in place at the moment which encourage and legitimize this culture within the social work or local authority teams? I really, really appreciate you coming on to Coproduce Care Chat. I've learned so much from talking to you. I'm really interested to find out more about how the CQC might get involved with local authorities. I think the point I was really thinking about, and I will raise when I do speak to them, is just having the regular inspection of local authorities that, say, GPs or NHS or dentists or care providers currently have. I think that might go a long way to changing this culture that you're talking about and identified.
Can I say, though, I think the difficulty with that, though, is that they're not the right people to do it. CQC inspectors are not public law experts. They are regulatory experts, and they may know everything there is to know about quality, but they're not in the position of buying services from an inadequate sum of public money. And if they went round regularly inspecting local authorities, I think that you would find it would become very, very, very bitter, and everybody would end up complaining to the Department of Health that this wasn't a feasible system. I think that it's being done on a rolling programme, but fundamentally CQC is the handmaiden of central government. And for that reason, central government, if not interested in putting back the 14 billion for adult social care, I can't see it conceivably financing regular inspection of local authorities commissioning out of public money. I can't see any way that that would be bearable for the Department of Health, because they'd be getting it in the neck double. Instead of just from one source, they'd be getting it from two.
So potentially that might not be popular, may not be helpful, but it definitely, there are some thoughts around it. I think it might be.
My feeling is you don't need to be an expert in public law, which is what is really required, I think, to evaluate local authorities. I think the ombudsman would be a better inspector of.
Okay.
But you don't need to be an expert in public law to say to people, show us your evidence of having actually learned about the liberty protection safeguards. Show us your evidence about actually having learned about the Care Act or having had a refresher course. That is much more prosaic and factual, and that's why I think it should be down to the organisation that regulates the social work staff themselves.
So that's the SWE.
Yeah.
Great. Okay. That's been fantastic. Is there anything else that you wanted, a burning issue? I mean, there's a lot in here already, but there might be something else that you wanted to just bring up before we close off for our chat.
Well, there is. It's this. CASCAIDr has been fortunate enough to be involved from the beginning to the end of a piece of advocacy for a particular couple who come from a council which shall remain nameless, because I do have some sense of discretion and tact. And they have been aggravated and extremely distressed by not getting the care or the housing that was promised for their autistic adult son when he finished at residential college. Ultimately, it's not the law very often that local authorities actually have to secure housing for people as part of adult social care. So in this case, the family wanted the young man to go into supported living, and so did the local authority. And so at the beginning, they were happy to have him home and just wait a short while for what they thought would be a concerted effort to find a care provider who could source a house and then set up an arrangement whereby the young man could move in. Well, fast forward to about 18 months later, nothing had been done, and the young man was beginning to present a safeguarding risk at home to his younger siblings and his parents. And they were left, apart from 15 hours or so a week, in sole charge of their challenging adult son. Well, I'm happy to say, because of CASCAIDr's involvement, the man is now properly accommodated and stable and having a much more bearable relationship with his loving family. But here is the thing. Once the council had done that, they thought that would be the end of it. What they did not appreciate is that there's been a legal development in the legal framework through a Court of Appeal case that makes it possible for a family to, in that situation, claim restitution of the money that the council had saved by not operating the Care Act properly. And I am delighted to be able to say that this week the local authority offered ex gratia and without prejudice, that means without admitting default, the local authority offered the full sum that the family claimed for 18 months worth of 2-to-1 care for their son. Now, as they had never expected to get any money back anyway, it is a life-changing sum of money, which is ultimately going to mean they don't have to move. What I would like to leave this podcast with is the thought, what then does that mean? Was the point of ever trying to save money by not implementing the Care Act properly, if human beings end up getting a right to restitution for unlawfully operated periods of a person's eligible assessed needs?
I think that is such a powerful point to make, and I really appreciate that you've shared that with us. And I think that story might be more common than people think, where there are a lot of families who are struggling and they don't know that they're entitled to the support. And also, it's just good to know that it's being recognised that if you are looking after someone with such high needs, that you don't have to suffer and you can get the support and that you have a right to it. So raising that awareness, I think, is so important. And also congratulations for supporting that family.
We are ecstatic because it is effectively the justification for about 3 years extremely hard work, bringing the charity to registration and then marketing and fundraising and learning and researching and supporting caseworkers and tweeting and blogging and networking.
And for people who want to know more about you, want to follow CASCAIDr, you've got a website. We'll put it in all the description of the podcast. And you're on Twitter and you're on LinkedIn, so people can find you. Is there any way that people can, if they wanted to donate or support the charity in any way, how would they do that?
If they go to our website, which is www.cascaidr.org.uk, on the right-hand side of the homepage, there's a big yellow button that says, please donate. Yeah. And that takes you through to a free system for being able to make the cheapest possible donation.
That's great. And there you go. You have it, people. If you want to support the fantastic work that Belinda and her team are doing, then please engage. And if you can, donate, because I think it's just fantastic. And I've really felt on this call such heart and determination to see justice for people who otherwise would be suffering or not feel that they're entitled to what they are actually entitled to, and effectively losing out. So thank you for sharing that information, your story. We'll definitely keep track of what you're doing. And I'd love to have you back on after people have heard this to talk about some other issues that people might want to know about, or some more fantastic cases that you've been successful at. So
thank you very much. Thank you for the opportunity. It's been lovely to talk to you and to feel that people are interested. So thank you.